A great many of you have requested today's video, which is on e-scooters and whether e-scooters can be used on UK public roads or pathways. E-scooters are funky, fast and potentially a lot of fun, but before you rush out and buy one, I suggest you watch this video all the way to the end. But first of all, if you're new to me and my channel, I'm a barrister who helps you understand law. So please hit that subscribe button, it helps my channel grow and your questions might find their way into a future video just like this one today. And if you've got other questions that don't make their way into this channel, they might find their way onto Black Belt Secrets, my sister channel, also linked below. So as usual, the bottom line first. Unfortunately, e-scooters cannot in general be used lawfully on public roads or pathways. But the good news is, in July last year, the government initiated a trial to essentially assess e-scooters and their suitability for use on public roads. Many of you have raised questions as to whether or not they are mechanically propelled vehicles and whether they should be mechanically propelled vehicles. So those are some of the questions I'm going to address today, because I've personally been very interested in buying one of these, but of course I look up the rules and the regulations first. But of course they are not permitted yet, but it doesn't stop me being interested in researching the area and producing a video for you guys. So starting with the overarching legislation, as I often do, Section 63 of the Road Traffic Act 1988 makes it an offence to use a vehicle on a road without an approval certificate for that specific type or class of vehicle. And at present there is no approval type specifically for e-scooters, because of course this legislation was brought about before the invention of e-scooters. And secondly, under the same act, Section 34 makes it an offence to use any mechanically propelled vehicle on a footpath, bridleway or restricted byway. And again, as I said, this legislation was drafted many years before the invention of e-scooters, and many of you have said that they shouldn't fall into the category of a mechanically propelled vehicle because it doesn't have an engine and pistons like a normal engine would. However, this is where we look to case law when these specific scenarios are not covered by the legislation and the courts have looked at specific facts, considered the legislation and made a ruling. One such case in the year 2000 in DPP and Saddington, the High Court considered a scooter that had an internal combustion engine and considered that that was a mechanically propelled vehicle. A couple of years later in 2002, in the case of Winter and DPP, the High Court considered the use of the Citybug electric scooter and whether or not there was an insurance requirement of the person using it. Ultimately, the court found that there was a compulsory insurance requirement for such e-scooters and the appellant had been properly convicted of using a vehicle without insurance. Similarly, and looking at it from a slightly different angle, in 2011, in the case of Coates and the CPS, the High Court was required to look at the statutory framework for the use of segways and whether someone was properly convicted for riding on the footway contrary to the Highways Act of 1835. The High Court upheld the conviction and likened the Segway to a carriage, either by analogy to a bicycle or some other kind of motor vehicle. But then many of you will think e-scooters should surely be allowed to be used on a cycle path. But sadly, Section 21 of the Road Traffic Act 1988 prohibits the driving or parking of any mechanically propelled vehicle on a cycle track or any other area that is dedicated to pedal cycles. So this rules out the possibility for e-scooters on a cycle path as well. However, as I said, following a consultation, there are trials going on around the country for the government to assess e-scooters and their suitability. Following a consultation, 2017 individuals and 177 organisations submitted their views, and based upon the views, these trials have been going on throughout the country. But of course, there has been some backlash against the trials for e-scooters, and some campaigners have been calling for the end of the trials. This is because some people have been hit and injured, because some people have been using them inappropriately, or simply because some collisions have been unavoidable, with, for example, those who are partially sighted or blind. But as with everything else, there is always a balancing exercise, and one of the arguments in favour is that the use of e-scooters will mean less cars on the road, which of course means less emissions and is better for the environment. My prediction is that the ultimate outcome is that e-scooters will be allowed, but they will be treated as some kind of moped and subject to the same kind of insurance requirements, probably helmet requirements, and possibly some kind of license or certification for using them. Depending on the power of the e-scooter, it may well go as far as a full-blown test, but we will have to see what happens as the law unfolds. But in the meantime, the bottom line is, unless you are part of one of these trials, the only legal place to use an e-scooter is on your own private land, which kind of renders them useless as a transport device. But as with everything else, the safety of the device is likely to come down to the quality of the manufacturing, but most importantly, the person using it. So in the meantime, remember that if you run out to buy an e-scooter, that you can't just use it on public roads, as I initially hoped that we could. But in fact, you can only use it on private land, and we will have to wait till the end of these trials and any decisions made as to whether or not they will be allowed generally to be used on public roads or cycle paths. So do stay tuned and make sure you subscribe, because I will update as to any further developments in the law. In the meantime, stay humble and subscribe.